Hello and welcome to today's lecture. The topic for our today's lecture is Uniform Civil Code Issues and Challenges. The main objectives of our today's topic are: number one, to understand the concept of freedom of religion; number two, comparative analysis of freedom of religion under the Constitution of America and India; role of judiciary in interpreting freedom of religion; constitutional history of Uniform Civil Code; scope of Uniform Civil Code and personal laws. The foundation of the present legal system in India was laid down by the Britishers. They succeeded in laying down uniform substantive and procedural laws almost in all areas of law. However, in some civil laws, viz. Marriage, divorce, maintenance, adoption, etc., commonly called personal laws, no uniform law was laid down. The first and the second law commissions were asked to prepare a draft of uniform civil laws, which would be applicable to all the communities irrespective of their religion. But they doubted the wisdom of uniformity in these laws and consequently left them untouched. The Second Law Commission even objected the codification of the Hindu and Muslim personal laws. After independence, legal position in the area was intended to undergo a change. The new constitution, which was adopted on 26 January 1950, incorporated a provision in this regard in the form of Article 44. The position did not change substantially, as the provision did not create a definite obligation on the state in this regard. Consequently, the personal laws continued to be administered as before. As time passed and need was felt to have a uniform civil code in order to bring unity in India. Presently, even a debate is going on throughout India regarding the implementation of Uniform Civil Code. The issue is not whether a Uniform Civil Code is to be adopted or not, but the real issue remains whether it can achieve unity. Freedom of religion. The Constitution of India remains first and foremost a social document. The majority of its provisions are either directly aimed at furthering the goals of social revolution or attempt to foster this revolution by establishing the conditions necessary for its achievement. However, the core of commitment to this revolution lies in Part 3rd and Part 4th, that is, in the fundamental rights and in the directive principles of the state policies. These have been described as the conscience of the Constitution. India is a secular state, but not an anti-religious state, for the Constitution guarantees the freedom of conscience and religion as a justiciable right. The Constitution, apart from guaranteeing this freedom through Articles 27 and 28, emphasize the secular nature of the state, for they secure to every person freedom from payment of taxes for the promotion of any religion and freedom from attendance at religious instruction or religious worship in certain educational institutions. In order to understand the scope of freedom of religion under the Constitution of India, it is important to understand the freedom under the Constitution of the United States of America, as it came up for discussion before the Constituent Assembly. The United States concept of secularism presents a significantly different pattern based essentially on the principle of freedom for the individual in the exercise of religion as a segment on the general scheme of the individual liberty. The First Amendment to the Constitution, which embodies the relevant provision, enjoins that Congress shall not make any law regarding the establishment of a religion or restricting free exercise thereof. Thus, the US Constitution guarantees not only the free exercise of religion, but also enjoins Congress not to make any law establishing a religion. The Establishment Clause remains a peculiar feature of the US concept of state secularism. The Import of this clause was explained emphatically by Thomas Jefferson with the help of a metaphor now quite popular in discussion on the subject. In the words of Mr. Justice Black in Everson versus Board of Education, neither a state nor the federal government can openly or secretly participate in the affairs of any religious organizations or groups and vice versa. In the words of Jefferson, the clause against the establishment of religion by law was intended to erect a wall of separation between church and the state. It's worthwhile to mention that some proposals were made before the Constituent Assembly of India for the adoption of the very language of the First Amendment for the protection of freedom of religion in the Constitution of India. These proposals came in the form of amendments to the officially proposed draft of the constitutional provision. These proposed amendments were negated by the Constituent Assembly. The Establishment Clause has been fraught with inherent difficulties which had begun to be censored even when the Indian Constitution was on the anvil. The framers of the Constitution of India shared with the Americans the ideology of the Free Exercise Clause. They also believed that the state should neither sponsor nor favor any religion and should treat all religions with tolerance and equality. But they were skeptic of the aspect of the non-establishment clause which would take separation between church and state to the extreme where it bordered on hostility and began to operate as a denial of religious freedom itself. Article 25, the principal article in the Constitution of India on freedom of religion reads, "Subject to the public order, morality and health, and to other provisions of this part, all persons are equal, entitled to freedom of conscience and right to freely profess, practice and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. B. Providing for social welfare and reform or throwing out open of Hindu religious institution of a public character to all classes and sections of Hindus." The Supreme Court in Commissioner HRE versus Swamir laid down that the freedom guaranteed by Article 25 is not confined to mere belief in religion, but also to exhibit belief in outward acts and to propagate or disseminate religious ideas for the edification of others. In court's opinion, the definition of religion given by US Supreme Court in Davis versus Benson is inadequate in the Indian context. In this case, it has been observed that the term religion has reference to one's views of his relation to his creator and to the obligations they impose of his reverence or being and character of obedience to his will. It is often confounded with cults or form of worship of a particular sect, but it is distinguishable from the latter. The court expressed doubt whether this definition of religion could have been in the minds of the framers of the Constitution. The court observed, "Religion is certainly a matter of faith with individuals or communities, and it is not necessarily theistic. There are well-known religions in India like Buddhism and Jainism which do not believe in God or intelligent first cause. A religion undoubtedly has its basis in a system of belief and doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine or belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe rituals and observances, ceremonies and modes of worship which are regarded as integral part of religion. Again, the Supreme Court in Rati Lal and others versus State of Bombay reiterated this view and laid emphasis on the point that religion has its outward expressions in acts as well. In Dargah Committee Ajmer versus Sayyid Hussain Ali, the court observed that this freedom guarantees to every citizen not only the right to entertain such religious beliefs as may appeal to his conscience, but also affords him the right to exhibit his belief in conduct by such outward acts as may appear to him proper in order to spread his idea for the benefit of others. The freedom of conscience remains the inner freedom of the citizen to mold his own relationship with God in any way he likes. In this context, Bijoy Emanuel versus State of Kerala, the Supreme Court, reversing the decision of the High Court, held that there is no legal obligation in India on a citizen to sing the national anthem. In the instant case, the children belonging to Jehovah's Witnesses of the Christian community were expelled from the school for refusing to sing national anthem, which had been made compulsory by a circular of the Director of Public Instructions. Their expulsion was challenged on the ground that it violated their fundamental right under Article 25, Clause 1. According to them, singing the national anthem was against their religious faith, which did not permit them to join in any ritual except when it is in their prayer to their God Jehovah. While reversing the decision of the High Court, the Supreme Court observed that the question is not whether a particular religious belief or practice appeals to our reason or sentiment, but whether the belief is genuinely and consciously held as a part of the profession or practice of religion, and our personal views or reactions are irrelevant. If the belief is genuinely and consciously held, it attracts the protection of Article 25, but subject, of course, to the limitations contained therein. While the right to freely practice religion, subject to limitations of public order, health and morality, is guaranteed, there is no such protection to activities which are economic, commercial or political in their character, though they are associated with religious practice. It may not always be easy to say if any particular matter falls under essential religious practice or is only secular, commercial or political activity which has come to associated with the religion. In some cases, like Muhammad Hanif Qureshi versus State of Bihar, the court has tried to spell out some activities like the sacrifice of cows on Bakri Eid, not an essential part of Islam. However, it has been rightly observed by H.M. Sirvai that the broad general contention that under Article 25, Clause 2, Subclause B, all secular activities which may be associated with the religion but do not constitute an essential part of it are amenable to state regulation, can't be supported. First, because what constitutes the essential part of a religion is primarily to be determined with the reference to the doctrines of that religion itself. Secondly, because the fact that religious rites and ceremonies require the expenditure of money or the purchase and use of marketable commodities, which would not convert the rites and ceremonies into economic or secular activities. The remaining matters of religion within the meaning of Article 26, Clause B, the above judgments reveal that religion is not merely the name of belief or faith. it is certainly something more. Had it been confined to mere belief or faith only, there would have been no room for the inclusion of Article 25 and 26 in Part 3 of the Constitution. Personal laws as such cannot be separated from the religious freedom guaranteed by the Constitution. Uniform Civil Code and Personal Laws. Article 44 of the Constitution contains a directive principle of the state policy. It states, "The state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India." The draft article, now Article 44, nurtured the state for debates on personal laws in the Constituent Assembly. Mr. Ismail and other members, viz. Mr. Naziruddin Ahmad, Mr. Mahbub Ali Beg, Mr. B. Parker Sahib Bahadur, and Hussain Imam, suggested amendments to draft Article 35 in order to protect personal laws. Mr. Muhammad Ismail suggested the addition of a proviso to Article 35, provided that any group, section or community of people shall not be obliged to give up its personal law in case it has such a law. The reason stated by Mr. Muhammad Ismail was that since the right to follow the personal law is not only the part of the way of life, but also the part of their religion and culture of those people who have been following such laws for generations. Any interference, therefore, in this regard would tantamount to taking away the way of life. The Constituent Assembly, however, rejected all these amendments and adopted Article 35, now Article 44, in its present form. Since then, the issue of adoption of Uniform Civil Code has been repeatedly debated. The judiciary, through its different pronouncements, has equally added to the debate. In particular, the prominence to the debate was gained by the observation of the Supreme Court in Sarla Madgal versus Union of India. The court in this case desired the government to adopt a uniform civil code under Article 44 in order to protect the unity and integrity of India. However, the main issue in this case was regarding the status of marriage between two persons professing the same religion if one of them converts to another religion. Yet, Justice Kuldeep Singh raised the question of Uniform Civil Code in order to stop Hindu husband to get converted to Islam. He further held that Uniform Civil Code did not violate religious freedom. The apex court in Shastri Yagnaparshadji versus Muldas Burdardas Vaishya observed that the matters of religion include religious ceremonies, practices, and rites which are essential for the practice of religion, and state cannot interfere in the exercise of these rights except when they are contrary to public order, health, and morality. In order to protect and safeguard personal laws, the Delhi High Court in Harvinder Kaur versus Harvinder Singh went a step ahead by ruling out the application of Articles 14 and 21 in family matters by calling these provisions as like pushing a bull into a china shop. Later on in Saroj Rani versus Sudarshan, the decision of the High Court was reaffirmed by the apex court. The Britishers, during their rule in India, succeeded in laying down a uniform legal system in almost all the areas of law except some areas of civil law, commonly known as personal laws. They inherited this legacy from the earlier legal system. During the Hindu period and Muslim period, in family matters, the laws of respective religions were applied to all subjects. The policy of non-interference was followed by almost all the rulers before the British period. The British rulers retained this system till the end of their rule. They too attempted to bring uniformity in these laws. However, keeping in view the wisdom and essence of these laws, they failed in their attempts to do so. Therefore, they left them untouched and maintained status quo. The diversity in the application of the personal laws was even acknowledged by the Privy Council in Skinner versus Ode, wherein it stated, in India, however, all or almost all the religious communities of the world exist side by side. While Brahmins, Buddhists, Christians, Mohammedans, Parsis and Sikhs are one nation, enjoying equal political rights and having perfect equality before the tribunals, they coexist as separate and very distinct communities, having distinct laws affecting every relation of life. The law of husband and wife, parent and child, the descent, devolution, and disposition of property are all different, depending in each case on the body to which the individual is deemed to belong, and difference of religion pervades and governs all the domestic usage and social relations. In order to make administration of justice strong and result-oriented, they appointed Hindu and Muslim law officers. Their function was to elucidate religious-based laws to English judges who had no knowledge about these laws. Presently, the diversity in the personal laws is being viewed as a threat to national integration. True, it is that the essence of uniformity in all laws sound logical, but using it as a tool to bring unity and integrity of the nation seems to be superfluous. The Apex Court has rightly observed in Pannanlal Bansilal versus State of Andhra Pradesh that adoption of a uniform civil code can be counterproductive to unity and integrity of the nation. The personal laws not only vary from community to community, but even within community itself, they vary greatly. Clause 1 of Section 7 of Hindu Marriage Act sets an example. It says, a Hindu marriage may be solemnized in accordance with customary rites and ceremonies of either party thereto. The act does not specifically stipulate ceremonies, but it leaves it to the customary practices observed by the parties. Same is true about Muslims who follow different mazhabs. They are divided into sects and subsects. The two big sects are Shias and Sunnis. Both Shias and Sunnis are divided into 38 subsects. The personal laws derive their authenticity from the religion itself, and therefore diversities are bound to be there. Besides these personal laws, the Special Marriage Act also governs family matters. The special and distinguishing feature of this act is that it is a secular law. Interreligious marriages are not generally being allowed by the personal laws, but under this secular law, religion is no bar to such marriages. Parties belonging to same religion or different religion are free to marry under this secular law. This secular law lays down uniform law to all marrying parties. Even in the matters of succession, the parties are governed by the uniform law, viz. Indian Succession Act 1925. However, the Parliament, by an amendment in 1976, added Section 21A to the said Act, which disturbed the special and distinguishing feature of this secular enactment by introducing a religious element. The effect of the amendment exempted the Hindu marrying parties from the ambit of Section 21. If any party to marriage irrespective being Hindu, Muslim, Christian, etc., is governed in the matter of succession by a common law. Why an exemption for Hindu was made? If it is not possible to have a uniform secular law whereby even an option is provided to the parties to avail it or not, how is it possible to replace the whole gamut of religious based personal laws by one uniform law? The Special Marriage Act, instead of becoming a catalyst for unity and integrity of India and paving way for abolition of personal laws, lost rationale by this amendment. The amendment itself reinforces the fact that in a heterogeneous society like India, a uniform civil code is neither feasible nor practicable. The advocates of uniform civil code believe that such code has a potential to unite India, and accordingly its enactment is always highlighted in reference to national integration. The rhetoric overlooks the essence of personal matters, viz. Marriage, maintenance, divorce, etc. in one's life. Marriage and religion, divorce and religion, maintenance and religion are deeply interlinked and cannot be divorced in the name of unity and integrity of the nation. The strict adherence to these laws cannot permit uniformity of any sort. The reality is that diversity in these laws reveal the essence of institution of family in civilized societies. Any attempt to unify these laws will be disastrous, not for the institution of family, but also for the society as a whole. In a country like India, the unification of these laws will negate not only the essence attached to the family as an institution, but also philosophy of its secular principles. Therefore, no attempt should be made to abolish personal laws, as rightly said by H.M. Sirvai. A common civil code for the whole of India is an illusion born of the desire that the people of India would be one people if they had common civil code. Just as the apparent sheet of water in a desert disappears as you approach it, so also a common civil code for the whole of India vanish as you try to formulate it. With this, we come to the end of today's lecture. Hope you have understood it well. Thank you for watching.